Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-7118, EIG Energy Fund 14 LP et al. Versus Petroleo Brasileiro SA, appellants, Odebrecht SA et al. Mr. Marotta for the appellant, Mr. Goldman for the appellees.
Mr. Marotta, good morning.
Thank you, Judge Henderson, and may it please the court, Sean Marotta on behalf of the appellant Petrobras. In what the parties call EIG 2, this court held that on the facts alleged in EIG's operative complaint, EIG had made out a prima facie case of jurisdiction over Petrobras in the United States. But the allegations in EIG's operative complaint have not been borne out by the summary judgment evidence. And for that reason, EIG 2 does not control this case. First and most importantly, this court credited allegations that Petrobras had targeted U.S. investors for SECE, including EIG, but discovery revealed that it was the other way around. EIG and potentially other U.S. investors targeted Petrobras for investment in SECE. What the summary judgment evidence revealed is that EIG approached Petrobras about the potential to invest in SECE, that Petrobras had no interest in taking U.S. money for SECE, and that EIG saw its task as convincing Petrobras to take money for SECE. And in fact, by the time of March, when SECE was handed off to be a separate and independent company, 90% owned by entities that were not Petrobras, EIG admitted it had never been solicited for money, and it still had not made an investment decision. In short, EIG was targeting Petrobras, trying to get Petrobras to take the money for SECE. And in fact, when SECE did close a first round of funding, it did so without any U.S. investors.
Well, let me ask you this. In the opinion from the previous panel on motion to dismiss, do you contest that your client sent a presentation containing a, quote, cautionary statement for U.S. investors, or that you created one of these tips to facilitate foreign investment with regard to this SECE project? So
there are two separate allegations, Judge Henderson. The first one with respect to sending the presentation. In fact, what the summary judgment evidence showed, and this is JA 1236, showed that the presentation that contained that cautionary statement you referred to came from Societe Generale. It was an old colleague of Mr. Corrigan, who was working at EIG, and said, hey, I hear you're interested in investing in Brazil. Here's something you might be interested in that I got. So Petrobras did not send that presentation to Mr. Corrigan that contains that statement. That was the allegation at motion to dismiss that, of course, this court had to take as true, but it's not what the summary judgment record revealed. With regard to FIP Sandus, which is the entity that you referred to, Judge Henderson, yes, Petrobras was the architect of that structure, but foreign investment is not the same thing as U.S. investment. There are countries in the world other than the United States that Petrobras could have been considering when it created that particular structure. And there's no evidence that there was an intent to solicit U.S. investment through creating that structure. In fact, there were all number of sovereign wealth funds and other investors outside the United States that Petrobras could have possibly considered as investors.
Can I ask a procedural question? I don't believe I saw it in your brief, but correct me if I'm wrong. Are you contending that the district court found the fact to be undisputed that was really in dispute?
No, I think what's unusual in this case is we lay out our statement of facts in the blue brief, literally directly just taking the district court's opinion at face value, because that's what we have to do on an interlocutory appeal from summary judgment. We're contesting immunity in this way. It's really EIG that's sort of rummaging through, I think, the summary judgment record to pull up things. So no, they moved to dismiss. That was referred to the merits panel, but we just take the facts as we find them. All we're asking this court to do is to say the facts as related in the district court's opinion as taken to be undisputed. Does that add up to what this court called targeting in EIG 2? That's a legal question. I think EIG has this conception that the abstract legal question on an interlocutory appeal of this sort has to be like a 1292B sort of novel question of law. But as the Supreme Court has made clear, that is not the standard when it comes to interlocutory immunity.
Can I ask, why do we even need targeting? In the prior opinion, we said targeting is sufficient to establish a direct effect, but the statutory standard is direct effect. So let's suppose they had made statements just to the universe as if they were issuing a prospectus or something. And as a result of those statements, a US investor took dollars in America and sent them off to Switzerland as part of this investment. Why isn't that a direct effect? And, you know, I'm thinking of the line from Weltover, which is the defendant did something, and as a result, in that case, it was money that should have flowed into the US didn't. In this case, it would be money that shouldn't have flowed out of the US did.
Well, I think the concern that this court's and all the other circuits cases had is that a sovereign shouldn't be hailed in the United States without doing something that, I hate to say targeted, because unfortunately a lot of these words kind of loop back in on themselves when we're talking about focus of behavior, but on a focus of behavior that is not referenced to the United States. So I think in terms of statutory standard, it wouldn't be direct then, because it is sort of dispersed throughout the entire world in this case. So that's why the courts have always said—
Why does that bear on directness?
I think it bears on directness because it would be an indirect effect in the United States to the extent that, and remember, it's the suit must be based upon the actions that cause the direct effect in the United States. So what this court's cases and all the other courts' cases said, merely suffering a harm in the United States, the mere fact that money has left your pocket is not sufficient to create a direct effect. And as a result, there must be something more. And the something more, this court held in the EIG2 was the targeting. But even if you conceive of the something more as being something else, there isn't in this case. Because, and I think it would be quite troubling if every time a US investor is essentially going after a foreign sovereign and the foreign sovereign picks up the phone or takes a meeting in response to that outreach, they would then be subject to the United States suit.
So if Seche said, we welcome investment from any and everywhere, and they happen to get US investment, but they don't target US investment, what's the result there?
I think there wouldn't be jurisdiction there, and I'll just emphasize, Judge Wilkins, there is an important difference between Seche and Petrobras here. Because Seche, and this is actually one of the ways in which this case on summary judgment differs quite dramatically from the facts that were alleged in EIG2. In EIG2, it was alleged, and this court credited the allegation that Seche was just an instrumentality of Petrobras that was created to carry on this bribe scheme. But what summary judgment evidence revealed is Seche was actually formed for the real purpose of creating drill ships. And it was 90% owned by folks who weren't Petrobras, sophisticated Brazilian and other investors who had full control over the company the same way any other shareholders do. So I think a key point, Judge Wilkins, is that Seche is, one, a break in the causal chain in our argument, and two, you just can't lump Petrobras and Seche together when talking about their conduct. But when it comes to Petrobras's conduct, to the extent they were willing to take meetings with anybody, that's not, we would say, targeting of the United States. It's simply picking up the phone. And that's why we refer to the personal jurisdiction case.
I'm getting back to Judge Katsas's question. Let's suppose the undisputed facts were that Petrobras said, we want investment from any and everybody, we welcome it. And those were the operative facts. As Judge Katsas, at least his question alluded to, targeting isn't necessarily the test. We've said targeting is sufficient. But let's suppose those were the facts. Is that enough to result in a direct effect?
I think it'd be a harder case for me, Judge Wilkins. I don't think it's enough, however, because it would still not be what this court and the other circuits have said, but something more. Because we know certainly from this court's cases that merely losing money in the United States is not sufficient to create a direct effect in the United States. There has to be something on top of that. So if all there is undifferentiated information that is out in the world and the EIG says, boy, this sounds like a good deal. And, Petrobras says, well, goodness, your money's as good as anybody else's. Sure, we'll take it. I don't think that constitutes a direct effect in the United States. particularly where, as you have here, all of the meetings up to the time of the point of investment were occurring in Brazil. They were coming to Brazil to talk to a Brazilian company about a Brazilian investment. And I understand under the third clause, you don't necessarily have to have physical conduct in the United States, but whether you know whether somebody is targeting the United States or directing its actions towards the United States, and that's what differs this case from Atlantica, is are you going to the United States? And the answer is no.
What case do you have in mind for the need something more proposition? Is it Odeyama?
I will have it back for you when I come up on rebuttal, Judge Katsas. I think it's a number of this court's cases.
Okay.
But I will certainly have it for you in rebuttal. Unless the court has
All
further
right,
questions.
give me a couple of minutes to reply. Thank you. Mr. Goldman?
May it please the court, my name is Daniel Goldman. I represent the appellees in panel 11. Judge Henderson, you asked a question about the promotional materials that had the cautionary statement for U.S. investors. Petrobras used that in pitches to multiple U.S. investors, not just to EIG, to U.S. banks, to private equity firms, conferences. It was widely distributed. The document that EIG received, district court found, was a basis for the fraud finding and summary judgment, regardless of whether it came from Societe Generale, because Petrobras put that document out in the stream of commerce. In terms of Judge Katsas's question about targeting, targeting is not part of the statute. Simply have to have foreign conduct, commercial conduct that causes a direct effect. The targeting concept originated in the Antares case in the Second Circuit, where in that case, it was very different than this case. In that case, Nigeria impounded a plane in Nigeria that just happened to be owned by US LLC. That was the only connection. And the Second Circuit said, well, that's happened. That's law. That's not jurisdiction. And then the Atlantica case took that and said, well, there's got to be something more when there's when the injury in the U.S. in the tort case, when the direct effect tort case is a U.S. injury, there has to be something where it cannot stand alone. And that was this court's language in the prior opinion. It cannot stand alone. In this court's prior opinion, the court found that the EIG's allegations clearly made it so EIG's injury did not stand alone. And the evidence bears it out. Whether or not you engage in the semantic games of what's targeting and what's not. Because, as Judge Henderson correctly pointed out, from day one, Petrobras sought international investors, including U.S. investors. The structure of the investment vehicle, it's called the FIP, was meant to encourage international investment, to give international investors, including Americans, a tax break. Faraz from Petrobras in 2009 did a roadshow in the U.S. where he met with the U.S. Exim Bank to seek over $1 billion of debt capital. Petrobras created promotional materials in English with a cautionary statement for U.S. investors and distributed them widely. Petrobras met and on many occasions EIG in Brazil and also sent emails to the U.S. and let EIG into the data room, which contained English materials that were basically pitch books for this project. And this was an enormous project, 28 drill ships, $700 million apiece, one of the largest capital projects in history. So of course they were going to seek international investors. They did it at every structure of the capital. They did it in the A equity that EIG invested in. They did it in debt. And they did it for the B equity, which was going to be the operators of the ships who were also going to take equity in the deal because they wanted to get, as you might expect, a number of U.S. companies who were going to operate in these drill ships were also going to take equity. So it was an enormous project with international investors, including American investors from all over the world from day one.
Let me ask you this about targeting, because I think that's become some sort of a issue in this case. To me, targeting in the economic realm is like marketing. I mean, when companies say, well, we're going to target teenagers or we're going to target old people or whatever, they're talking about marketing to them. That's all. And this was clearly, at least in my view, marketed to the United States and to EIG in particular.
Right. I think that under any definition of the word targeted, EIG has met that and established its prima facie case. And, but Atlantic, of course, talks about targeting, but it also talks about whether or not the defendant in that case contemplated U.S. investment. Petrobras tries to have a bright line between contemplation and targeting. I don't think there's such a bright line. I think it was essentially the same thing in this case. They contemplated, they targeted, they had numerous potential U.S. investors, both before and after SECE went operational, which was actually May of 2011. Petrobras remained involved in trying to raise money, both before and after SECE went operational from potential U.S. investors.
Could I ask you about the merits? We have cases for the proposition that as long as an assertion of immunity remains unresolved, you can't make the foreign sovereign litigate the merits. And as far as I can tell here, the only thing the district court has done with respect to immunity is deny summary judgment. So how do you defend the entry of a summary judgment on the merits while, at least as far as one can tell from the papers, the immunity issue is still open for trial?
Well, that's an interesting question. I think perhaps you're referring to your own case, the process.
I'm sorry.
I said, I think perhaps you're referring to your own case, the case that you
ENID, yeah. Judge
Right.
Wilkins and I.
So what the district court did is it first resolved foreign sovereign immunity jurisdiction before it reached the merits. And it followed the roadmap set forth by this court. It first determined whether or not EIG had established a prima facie case based upon the three factors set out by this court in its prior opinion. Finding that EIG...
That's the substantive law of immunity. But in terms of rules of civil procedure, the only thing the court did was deny summary judgment. It didn't make findings, and it didn't grant summary judgment the other way.
He didn't grant summary judgment the other way, but the court has an obligation when jurisdiction is raised to make a finding. Jurisdiction. It's not just a summary judgment finding. Whenever jurisdiction is raised, the court has an obligation to go beyond the pleadings, go beyond, to look at the evidence and make a finding. If you look at his opinion, he said, I find there's jurisdiction, that Petrobras did not establish an affirmative defense. But there's one other point.
It reads like he's resolving the facts, but
the big difference, though, between this case and the Nigeria case, too, is that in the Nigeria case that you authored, Nigeria objected to any briefing on the merits. Here, Petrobras itself moved for summary judgment, a very different procedural stance. But I will say this, Petrobras has said on page 45 of its brief that the determination from the district court is not a conclusive determination. Well, as this court knows, to get jurisdiction under the collateral order doctrine, there has to be a conclusive determination. So Petrobras has effectively admitted, and we disagree, they have effectively admitted there's no conclusive determination, that there should, effectively no collateral, that the collateral order doctrine doesn't apply. But I think that the real point is this. Petrobras will continue to challenge jurisdiction because that's their own defense. They now have summary judgments on liability. I am sure that when we get to trial, they will continue to raise it until the district court is divested of jurisdiction.
I'm confused here. When a defendant challenges the existence of jurisdiction, they can file a 12B1 motion. And then either that's granted or denied. And then that's an appealable order, generally in this context. If a plaintiff says after kind of going through that process, look, there are no disputed facts as to jurisdiction, and we've taken all the discovery that we need to take with respect to jurisdiction. We don't think that we need to have a trial to determine whether you have jurisdiction. We think that you can essentially grant summary judgment in favor and find that there is jurisdiction here, that there has been a waiver of sovereign immunity. Why isn't that an appropriate way for a plaintiff to proceed in a district court to resolve jurisdiction where there's no dispute over the material facts?
That's a good question. And I think if you look at the way Judge Maida framed this, he said, I have to determine whether there are any disputed facts as to whether or not Petrobras has an affirmative defense, whether Petrobras meets its burden. He found that there were no disputed facts on that issue. Based on that finding, he determined that he had jurisdiction. So,
did your client ask him to find that affirmatively in briefing? Did you say, Judge, we want you to enter a judgment within the meaning of Rule 54, which is any decree or order that is appealable? Did you say, we want a judgment that there is jurisdiction here? And did you ask for that relief in the pleading?
We did not ask for that relief. And I think as a practical matter, plaintiffs general, we had jurisdiction based upon this court's prior. We did 2 years of discovery, reviewed millions of pages of documents, took many depositions. We had jurisdiction. So as a plaintiff, we were not going to then say, by the way, we want to make sure you have jurisdiction, Judge. Petrobras came in and challenged Petrobras jurisdiction. We opposed it, and the court found it had jurisdiction. Otherwise, the court would not have reached the merits. If the court did not think it had jurisdiction, it wouldn't have reached the merits.
When they challenged jurisdiction, did they challenge it by filing another 12B1 motion, or did they file a Rule 56 motion?
It was in the context of a Rule 56 motion. They did not file a 12B1 motion. Well, they could have, but they chose not to. And at the same time, they chose to file their own summary judgment motion on the merits. So they were litigated simultaneously. And EIG filed a motion, cross motion for summary judgment. That was granted, but only after the court determined that it had jurisdiction. And I don't think had EIG moved affirmatively, it would have been the same result. There would have been a finding that EIG had established its case. There would have been a finding that Petrobras did not meet its burden to establish affirmative defense. I think it's really a semantic difference. And while Petrobras may move in the future, 12B otherwise, or try to put in evidence, it's going to have to come up, obviously, with new evidence to challenge the court. It's going to, because what's interesting in actually telling is Petrobras did not submit a single one of its internal documents to challenge the prima facie case. It did not submit a single line of testimony from any current or former employees. It relied entirely on semantic games of what targeting is and hearsay testimony.
What I'm trying to understand is, in the district court's mind, does the district court believe that this case is over, that the court has entered judgment for your client and it's done, other than determining damages?
Yes. At this point, all we have is a trial on damages, limited trial on damages, and also mitigation, another issue, which is essentially a damages issue. So yes, if you were to bring up Judge Maida now and say, Judge, are we finished now? What do we have to do? He'd say we have damages and mitigation. That would be his response.
All right, thank you.
Thank you.
Thank you, Your Honor. Judge Katsas, let me start on the question I whiffed on. It was Uddenhembo, which is where this court worried about creating unilateral jurisdiction, and also in EIG 2 when it said, referring to Antares, we're not concerned about the some financial loss from a foreign tort cannot standing alone create jurisdiction.
Yeah, but that case, that's a little bit different. I mean, the concern about a foreign plaintiff being defrauded and then moving to the US for litigation reasons is very different from a US investor who's defrauded by statements projected into the world by the defendant.
But I think the concern that runs through both Onanhamo and the Antares case is that the mere loss of money in the United States shouldn't be enough to create jurisdiction, because otherwise it's just the plaintiff that's creating jurisdiction by the fact they are located in the United States. I think is the concern that's always been raised, and divesting a foreign sovereign of its immunity on the basis of the mere location of the plaintiff, which I think also runs across to the personal jurisdiction case.
I mean, it just seems, whether you think of this as a personal jurisdiction-like issue, a choice of law-like issue, a place of injury for extraterritoriality issue, if plaintiff in jurisdiction 1 harms a plaintiff in jurisdiction 2, it's perfectly common for the defendant to bring an action in his home forum.
I think it's common, but I think in all those cases we look for something more than the fact of harm, and I think that gets to
more than the place of harm. I mean,
think
that was the traditional choice of law rule.
Well, and then I think it gets to the discussion that EIG2 had about it's not clear whether you're in the place of harm. So I mean, I think part of the problem with EIG's argument is they say, well, if it's not that, then look at that. Well, if it's not that, look at the other thing, and they keep pivoting away as to what it is not. But I don't think they have a good theory as to what it is. I think as to Judge Henderson's question about even if you think of targeting as marketing, there's no marketing in the United States in this case. It's that EIG learned about this opportunity from a third party and then reached out to Petros saying, hey, we want in, and viewed its task over a course of several months as attempting to persuade Petrobras to take its money, which never even occurred until the handoff to such an entirely independent company. Finally, before I sit down, I'd just like to endorse the questions from both Judge Katsas and Judge Wilkins. If you read the district court's opinion, I can't summon the spirit of Judge Mehta up here, but the opinion is written as a summary judgment opinion. All the district court did was deny summary judgment.
Are there facts that you would like to contest going forward? I mean, this has a little bit of an unreal aspect to it. I mean, you were litigating jurisdictional issues and the merits issues simultaneously below, which you could have resisted if you wanted to. And the opinion reads as if Judge Mehta is resolving the immunity issue, finding facts or finding none of the facts disputed.
I don't understand Judge Mehta to be finding facts. I understand Judge Mehta to be taking the facts in the light most favorable to EIG. For instance, what are the inferences to be drawn from?
It doesn't read like the normal summary judgment opinion, which says defendant's evidence is X, plaintiff's evidence is not X. That's a genuine conflict, so we need to go to trial. It just reads as if here are the facts. Here's the record, and you lose.
It's the facts related in a particular light. The same way, for instance, a court may lay out a set of facts on a motion to dismiss, and everybody understands, of course, that's just the facts as related in the complaint, even though they're related in sort of an authoritative, factual tone. I think in terms of facts we'd like to contest, I don't want to prejudge my trial strategy, but I think, for instance, the Kevin Corrigan testimony and what inferences that are to be drawn from it. EIG has one view of what Kevin Corrigan's testimony meant about Petrobras's interests. We have a different view. And the district court said, well, it basically said, look, the Kevin Corrigan testimony, I view it in a certain way, but did not say, this is my holding, I'm entering judgment on this. Again, it was just in a summary judgment posture.
What I don't get is, I asked you whether there was some fact that was in dispute, and you said no.
Well,
what you seem to be saying is there were no facts in dispute, but maybe we can argue about what inferences should be drawn from those facts.
And if I misunderstood your question earlier, Judge Wilkins, I apologize. I took it in the context of the jurisdictional issue over the appeal, which the EIG had raised. And for the purposes of this appeal, we are not disputing the genuineness of anything.
And that was not my question.
Then I misunderstood the question.
I'm trying to get down to brass tacks of how a case is supposed to proceed through trial.
Right. Yes.
Okay, so if the district judge is in a posture where the district judge does not believe that there are any disputed facts with respect to jurisdiction. The district judge doesn't have to have a trial, does he? He or she?
Well-
The district judge can, if the facts are undisputed, rule yes, there is jurisdiction, or no, there isn't jurisdiction without having a trial. Can't that be a course of action that's permissible?
That can be permissible on summary judgment, but then understanding your question correctly, which I did not understand when I got up the first time, understanding your question correctly, we believe there are disputed facts as to the intent and interest of Petrobras as to whether it was soliciting or had the intent of seeking United States.
But that's not an argument you made in your brief anywhere.
Well,
I'm hearing it for the first time now in rebuttal at oral argument.
Well, it's not an argument we make in our brief because on an interlocutory appeal from an immunity issue, I can't get up here and say, you know what, the district judge misunderstood the facts that were at issue. And also, I'm not challenging Judge Wilkins because the district court didn't enter summary judgment.
Why can't you say that the district court improperly found something to be undisputed?
Well,
that was actually disputed.
As I understand the immunity case law, on an interlocutory appeal with respect to immunity, and this comes from the qualified immunity side, it is improper to raise an interlocutory appeal where the only issue you're raising is essentially the genuineness of a dispute of material fact, or whether the actual factual lay of the land in the district court supports the factual findings that the district court has related in its opinion. That's what you can't do on an interlocutory.
And only do that after the trial on the merits?
You can do it after the trial on the merits, though, as the Supreme Court says, it's not summary judgment anymore. You're just arguing about the trial record at that point. And second, the reason we're not challenging a hypothetical grant of summary judgment is because the district court didn't grant summary. There was no grant of summary judgment from the trial court, so there would be no basis for us to say that, oh, summary judgment was inappropriate.
So I'm trying to understand what you are saying the plaintiffs here should have done. They should have said, Judge, we ask you to find summary judgment in our favor on the issue of subject matter jurisdiction.
Yes. And if the district court had entered that, then I think I might be in a different position and I'd have to think about whether and how I could appeal that. But on the record as we have it today and under the procedural posture as we have it today, there was no grant of summary judgment, only the denial of Petrobras's.
Why should we, in order to address this issue, we have to make a disfavored discretionary decision to exercise pendent appellate jurisdiction, right? Why should we do that? Where I find it a little bit unclear exactly what the district court did. I find it very unclear whether you teed up this issue for the district court to say definitively resolve jurisdiction first before you get into the merits. And we're having this interesting academic debate about a partial summary judgment that can't affect your client until entry of final judgment. So why don't we just leave it to be worked out on remand? You go back to the district court and say, Judge, the immunity issue is still open. We want a trial on whatever jurisdictional facts you want a trial on. And if he grants you a trial, problem solved. If he doesn't, you maybe have a procedural argument about he cut you off too soon based on denial of summary judgment, but it just gets worked out in a little more concrete way.
Well, I think you should reach out and take it, Judge Katsas, for two reasons. First of all, is the respect that the United States gives to foreign sovereigns and its immunity in the United States courts. And the second is because I think the district courts could use guidance on this particular point. Obviously, Judge Mehta is an excellent district judge. And so if it could help and provide guidance to the district courts in the circuit to clarify the order of battle when it comes to these particular issues, I think that would be of great benefit to the district.
But when did you ever ask Judge Mehta to make a final order or judgment on subject matter jurisdiction before proceeding to the merits?
I don't have a citation for that, Judge Wilkins. I do not.
Well, you affirmatively didn't do that because you moved for summary judgment below on the merits.
We did.
You asked Judge Mehta to reach the merits without asking him to make a final ruling on jurisdiction. You didn't say, well, we're renewing our 12B1 motion here because we think that there's no jurisdiction and we only want you to resolve that at this time, right? That's not what you did.
That's right. We moved for summary judgment on everything together.
And all fact discovery has happened.
That's
It's
correct.
closed, right?
That's correct.
On the merits.
That's correct.
So how are you prejudiced at all by Judge Mehta if Judge Mehta thinks at this point we've had all the discovery? I don't think that there are any dispute of fact on the operative material facts relating to just discovery to go ahead and find that there is jurisdiction. How does that prejudice you?
I don't necessarily think it's a question of prejudice, Judge Wilkins, but rather the sort of core principle that we can't reach merits before jurisdiction, even if we think the merits are particularly clear, or even if we think the merits are undisputed.
I mean, I don't understand how any of that is consistent with Rule 1. Rule 1 of Federal Rules of Civil Procedure, which essentially says that the rules are supposed to be construed for the speedy, just, and inexpensive determination of every case.
But I think it gets back to Steel Co., which comes back, when the Supreme Court laid out this order of operations that said, look, even if you think you got really, really easy merits, sometimes you have to do hard jurisdiction ahead of it because of.
It really comes back to the immunity cases, which, they sort of help you because they give you a pretty bright line rule that you can insist on litigating jurisdiction first.
That's right.
But they hurt you because the immunity is waivable or forfeitable.
But we've always asserted our immunity from the jump.
This is not like subject matter jurisdiction in the sense you can choose to litigate.
That's true. If we never raise immunity, certainly it's not.
You didn't raise the sequencing issue. You litigated the merits and the immunity on parallel tracks on summary judgment.
That's correct, Judge Katsas, we did.
Just said the one thing the judge couldn't do is enter summary judgment against you, and you, based on the outstanding immunity issue. And I looked at your district court papers. It's that idea sort of there, but it's pretty fleeting, and there's no separate discussion of the immunity sequencing issues. So.
But I think with respect to waiver, of course, it's a settled rule that it's not the citations we give. It's not even sort of the fulsomeness with it. It's have we presented the issue, done it perhaps more clearly. And of course, the issue became clearer once we had the resolution from the district court, unless the court has further questions.
Thank you. Give us a recess.
Stand, please. This honorable court is again in session. Be seated, please. Case number 22-5334, Sandpiper Residents Association et al. Appellants versus United States Department of Housing and Urban Development. Ms. Miles for the appellants, Mr. Brewer for the appellee.
Good morning. May it please the court. My name is Kimberly Brown Miles for the appellant. This case is not moved for the following reason. The sole grounds for mootness that was presented by HUD in the district court was that because Sandpiper's owners had changed, the terms of the 2022 appropriation statute no longer provided funds for tenant protection vouchers, and the funds were no longer available. That was the only grounds for mootness that was presented by HUD in the district. HUD has the burden of showing that this argument is correct on both the facts and the law. This court reiterated in Zuckerman versus USPS that the party urging mootness has the heavy burden of establishing that a case is moot. HUD fails to meet this heavy burden. Plaintiff's concrete interest in this matter is to acquire decent, safe, and sanitary housing. This case is not moot for lack of appropriation funds. Funds for tenant protection vouchers are available under the appropriations accounting statute for fiscal years 2019 through 2021. Claimants meet the elements for vouchers for their claims that accrued during these years that would allow them to access decent, safe, and sanitary housing. HUD ignores the appropriations accounting statutes 31 USC 1552, 31 USC 1553, and 31 USC 1502B, and the equitable appropriations doctrine providing for availability of these funds. For example, in
Let
Westchester.
me ask you this question. I mean, suppose you are right and that the case is not moot in the sense that the relief that you are seeking could theoretically still be ordered, and it would grant some redressability to the injuries of your client, the relief being vouchers.
Yes, sir.
But turning to the merits, then you still have the problem that there's been no notice of deficiency that has been issued to the current owners of the property, and that seems to be a requirement of the statute before voucher eligibility.
And that's our argument, Your Honor, that there does not need to be a notice of deficiency for our clients to meet the elements for voucher relief for fiscal years 2019 through 2021, because the uncontested evidence in the record shows that the previous owner received a notice of default, and that's still within the ambit of the CAA provision. And as such, because we meet the elements for those fiscal years, that's the reason why our clients are entitled to voucher relief. Also, we want to know for the record.
So you're saying that they would get vouchers from funds from those appropriations as opposed to a later appropriation?
Your Honor, even for, the record has not been developed related to the current status of the project, and that it is in question in terms of whether the current owner whether there will be further another notice of deficiency issued to the current owner. In the record at this point, the last inspection that occurred at the complex in February of 2022, and that was the last documented status of the physical conditions of the property, the new owner was deficient. HUD had not issued a notice of default per se, but they received an unsatisfactory HUD inspection.
But I guess when you filed a lawsuit, though, I mean, you can't wait until the facts kind of turn out in your favor, and then hope you can get relief then. I mean, the facts or the evidence, so to speak, as to whether you're entitled to the relief, the district court is entitled to assess the evidence and the facts as of the time that one side or the other asks for judgment, right?
Yes, Your Honor.
So what difference does it make that in the future, a notice of deficiency might be issued?
The facts in the record indicate that the complex has not met decent, safe, and sanitary standards under HUD regulations. Moreover, Your Honor, the district court, moving to our other claim under the Fifth Amendment and fair housing, we set forth facts establishing a prima facie case of intentional discrimination that the district court also dismissed on mootness grounds. And we pled effective relief for those claims, even though, again, the burden is not on the plaintiffs to establish that a case is moot. I want to note for the record that even though district court did not, or indicated in the decision that we did not meaningfully identify other relief, we point the court to Rule 54C, which provides that every other final judgment should grant the relief to which each party is entitled, even if the party has not demanded that relief in its pleadings. Now, we don't concede that we did not meaningfully identify other relief available in our operative complaint, because we did, and I'll go through that in a few moments. However, under Rule 54, we need not have specifically pled that relief for a relief to be granted for our intentional discrimination claims. If I can go into the merits of our intentional discrimination claims for a moment, HUD is funding and administering a dual segregated PBRA system in Galveston, Texas. All the white PBRA projects and white census tracts have passing HUD inspection scores, while 67% of the units in majority minority census tracts have failing HUD inspection scores. HUD pays for PBRA housing in white areas that meet HUD standards, but does not do so in most of its Black area PBRA projects. HUD refuses to provide the assistance to our plaintiffs that would allow them to access decent, safe, and sanitary housing. So what we pled in terms of injunctive relief is not just for tenant protection vouchers under the CAA, which we still maintain that our tenants are, or our clients are entitled to. We also pled for injunctive relief for HUD to provide decent, safe, and sanitary units in neighborhoods without substandard conditions so that our clients could access decent, safe, and sanitary housing, which they are entitled to under the Housing Assistance Payment Contract and under HUD regulations.
Don't you have to plead that the reason that HUD denied the vouchers was discriminatory purpose or intent?
What we have pled is that HUD is providing different standards of PBRA housing to tenants based on race. And so it's not so much just limited to access to vouchers per se. HUD is not providing Black tenants decent, safe, and sanitary housing. And a similarly situated comparator is tenancy in a PBRA projects. White tenants, Your Honor, do not need access to vouchers, which would allow them to access decent, safe, and sanitary housing because they already have it. So there is not going to be a similarly situated comparator where HUD is going to give PBRA tenants vouchers and not Black tenants because they are not in that situations.
And what facts do you plead support or allege discriminatory purpose or intent in the way things, I understand you're saying that this is the way things are, but where's the agency's intent?
So we plead that on pages, it's on 231 and 234 in the record. And the standard for the unequal conditions that I referenced is based on HUD's REAC inspection score. So we set it out by project, by race of the occupants in those projects, and by location. And in the Galveston, Brazoria County locations, we set out that there are 5 white projects. None of those white projects have failing real estate assessment center inspection scores. That's HUD's inspection evaluation for PBRA projects. 67%.
Are they in control of that though? They just,
They aren't.
I guess, inspect the properties.
Very quickly to go over how PBRAs work. They are privately owned projects. However, they sign a contract with HUD agreeing that they will provide the tenants in that project decent, safe, and sanitary housing. And it is HUD's responsibility to ensure that those private landlords are providing that housing under HUD standards to those tenants. And HUD pays those owners a subsidy in exchange for them providing that housing. HUD is continuing to pay landlords such as the owner of Sandpiper Cove a subsidy while they're not providing decent, safe, and sanitary housing to the tenants in which they're housing. So the tenants sign a contract with the private landlord, that is true, but the landlord is responsible for providing the decent, safe, and sanitary housing under its contract with HUD.
And so the remedies that you're pleading for this discrimination, it's not just the vouchers?
We are asking for voucher relief because we also cite Hills versus Dutro, which indicates, in that case, it's a Supreme Court case, where that case stands for that a district court has the equitable authority when a constitutional violation is filed. In this case, we're pleading that HUD violated the Fifth Amendment in terms of intentional discrimination and for not providing decent, safe, and sanitary housing to Black tenants compared to white tenants. And in that finding, a district court has the authority to issue equitable relief to remedy that constitutional violation. So in this case, vouchers would provide those tenants with decent, safe, and sanitary housing, and they could use that mobile voucher to locate to whatever unit would take that voucher to access housing in integrated areas that are decent, safe, and sanitary. That answers your question.
All right.
I think-
If there's no other questions, we'll give you some time on rebuttal.
Thank you.
May it please the court, Simon Brewer for the Department of Housing and Urban Development. This case is moot for exactly the reason the district court held. Events have outrun the controversy such that no effective relief is available for plaintiffs' claims here. Following the sale of the Sandpiper Cove.
There's a legal dispute about whether vouchers are an available remedy. How does that show mootness? If you're wrong about the availability of the remedy, we can redress the alleged injury.
If we're wrong about the availability of the remedy, then the dispute would not be moot for that reason. But the court has treated.
So there's just a substantive law question about whether this remedy is available in light of the appropriation.
This court has treated the availability of appropriations as a mootness question. And that's because if there are no funds available to provide a remedy, then the appropriations clause forbids the court from providing effective relief. And so in cases like Shawnee Tribe, whether or not there are available funds has been treated as a question of mootness. And so for that reason, the district court treated it as a question of mootness here. It looked to the meaning of the appropriation statute and it determined that the funds would not be available in these circumstances. But that follows from the mootness framework, not necessarily exclusively from a merits framework.
I mean, I'm not sure it matters, but it just strikes me as more of a merit question.
Oh, we agree. At the end of the day, if the court determines this as a merits question, it can certainly affirm on merits grounds, and the department would treat that similarly. So, but we think the district court got it right because of the appropriations context here.
Well, why did the district court get it right? I mean, why can't the statute be read when it says that the secretary can pursue transfer project to an owner approved by the secretary under established procedures who will be obligated to promptly make all required repairs and to accept renewal of the assistance contract if such renewal is offered. Why doesn't that language obligate a successive owner to repair the property and essentially cure any notice of deficiency?
The new owner is required to make the repairs to the property, and the new owner here has agreed to do that.
Is the new owner required to cure the notice of deficiency? Is that what that means when you say that they're required to make repairs?
No, the notice of default terminated upon the sale, and that's because the notice of default is an owner-specific remedy, and it serves as the predicate for other owner-specific remedies in the statute. But upon the sale of the property and the transfer of the housing assistance payment contract, the new owner incurred its own obligations to HUD to provide decent, safe, and sanitary housing and to make sure that the property is in a condition that satisfies its regulatory and contractual obligations. And if the new owner becomes in default of those obligations, HUD can certainly issue the new owner a notice of default. But that has not happened in this case.
Why is that consistent with congressional intent? I mean, it just seems like it's a way to kick the can down the road without anything getting fixed.
I think Congress recognized that there may be times when pursuing transfer to a new owner who will undertake repairs is the best option for preserving one of these properties. And Congress has directed the department to take all steps reasonable to preserve these kinds of properties. But having the notice of default transfer over to the new owner or something like that would, in fact, undermine Congress's specification that transferring of the property is a remedy, because new owners would be extremely reluctant to take on these projects that had already had a notice of default issued if they could immediately face civil money penalties or debarment from federal programs that are other remedies also predicated on notice of default. So it makes sense that the new owner itself has to be in default of its obligations or those other remedies become available as to the new owner.
I mean, it seems that all of those sorts of things can be dealt with in a negotiation. You know, you can stipulate that, okay, we're not going to subject you to all of these other penalties right away. We'll give you this much time, but the notice has been issued, and in the meantime, if these tenants want to move and not wait for the repairs, then we'll give them vouchers.
I think Congress recognized that vouchers was one option, and it afforded HUD the ability to issue those vouchers without a requirement to issue those vouchers. But it recognized that there's a menu of enforcement choices here, of which vouchers is one, pursuing the transfer of the project to a new owner is another, and that circumstances will differ. And in this case, HUD pursued transfer of the project to a new owner after trying other remedies, such as requiring the previous owner to replace the management company.
Well, I mean, I guess that response is why it might be, reasonable for HUD to not exercise its jurisdiction to impose these other remedies on a new owner immediately. But that doesn't really answer the question as to why legally it couldn't be permissible for HUD to allow tenants to have vouchers right away while the new owner is trying to fix the property.
It's certainly true that HUD would have enforcement discretion in those circumstances, but I think the congressional scheme recognizes that the obligations imposed on owners are specific to those owners, and it didn't want to open the door to even the risk that HUD would immediately impose these kinds of entity-specific sanctions on a new owner and thereby undermine its tools. I mean, even if HUD could agree to forego those with respect to a new owner, new owners might be wary of purchasing properties.
How long has this voucher scheme at issue been in place? Just since 2018, or is it before that?
I believe 2016 is when it was first implemented, but I may be off by a year or so.
So the authority that was cited for why the notice of default doesn't transfer was, I think, a single declaration from a HUD employee. Is that all the authority you have? There's no regulation, there's no policy statement, there's nothing else?
That's correct. The HUD declaration sets forward HUD's understanding of how the notice of default and the enforcement scheme operates.
Do we owe that any deference?
We have not asked for any deference, but we think that's consistent with the language of the appropriations statute and certainly reflects HUD's experience administering the scheme and enforcing notices of default issued to owners in these types of properties across the country.
I mean, if the conditions of these properties hasn't improved and it's still basically have deficiencies that endanger the health and safety of the tenants, why would it make sense to interpret the statute to deny these tenants a voucher just for the sole reason that the property's been sold?
The property being sold is part of HUD's enforcement scheme of the statute. Selling the property and transferring the associated contract to a new owner that commits to making the repairs on the property, that secured financing to make repairs on the property, was, in HUD's view, a reasonable and economical way to conclude this enforcement action and bring the property into compliance. In certain circumstances, it could choose to issue vouchers, but it would typically do that as a last resort when other possible remedies have failed. And HUD, in its judgment, again, taking into account the conditions of the property here, had not yet been convinced that that was an appropriate
How
step.
long did they have to make the repairs?
The new owner?
Yeah.
I don't know that there's a specific timeline set forth in the record, but I can tell you that as of July, the repairs on the property were 85% complete, and currently the repairs are expected to be completed by November of this year.
And is that in the record somewhere?
That is not in the record, but certainly that would bear on if this case were remanded to the district court, the propriety of issuing a preliminary injunction.
Isn't the textual basis for your argument that the statute says it's when the owner has received a notice of default?
That's correct.
Yeah, because Judge Wilkins was just asking you, what is the basis for this position that you're taking?
That's exactly right, Judge Pan. It is the owner that must have received a notice of default. And at the current time, the owner has not received a notice of default, even if some prior owner has.
And this case comes to us in the posture of having been dismissed as moot. And I'm wondering if that's the proper way to look at this, because I think the intervening event is that there was a change of owner, but wasn't there an amended complaint that named the new owner as a defendant? And doesn't that, I guess, defeat the mootness argument, but perhaps this should be dismissed under Rule 12b-6 for failure to state a claim instead?
No, Your Honor. So in the same posture happened in the Del Monte case that we cite in our brief, where an amended complaint was filed after the putative mooting event, and this court decided that case on mootness grounds about whether the intervening event, since the filing of the initial complaint, had mooted the case. And that's exactly the same here. The intervening event occurred between the initial filing of the case and the filing of the second amended. And so the district court appropriately treated that as a mooting event.
Any other?
We urge you to
All right, thank
affirm the judgment of the district court. Thank you.
Thank you. All right, Ms. Brown-Miles, I think you're out of time. We'll give you 2 minutes.
Thank you, Your Honor. I wanted to respond to my colleague, Mr. Brewer's, some statements regarding the statutory framework of the CAA. HUD is sort of conflating the menu of options that they have against the PBRA owner upon a failing REACT score and the tenant protection vouchers. And we go into that extensively in our briefing, but I want to reiterate it here, that it is clear that under the statutory framework, HUD has about 9 options in terms of enforcement options against the owner. And one of those options is to transfer the project and sell it. And I want to highlight that that new owner is under Section 219 C2D. That's under the 2021 Appropriations Act. But each act reiterates sort of similar language, that the new owner is obligated to promptly make all repairs and to accept renewal of the assistance contract if such renewal is offered. In addition, HUD's own guidance emphasizes that tenant protection vouchers and its enforcement options against the owner are completely separate. So they're separate in the statutory framework. Tenant protection vouchers are in paragraph 2 of the 2023 CAA. And again, that allows them to have the option to give tenant protection vouchers while they're working out whatever enforcement process that is going through with the owner. So again, one of their enforcement options is to abate the Section 8 contract. And typically when that happens is they cancel the contract, and then the folks, in order to continue to receive decent, safe, and sanitary housing under their subsidy, they get vouchers. Well, the funding for voucher relief is separate. And that's why Senator Rubio, which we go into extensively in our brief, wanted this funding, because it allows HUD to pursue its enforcement options and to do whatever it deems to be appropriate in terms of the agency's discretion, but it allows folks to be out of those dangerous, hazardous situations more quickly without having to HUD to be forced into the decision-making of whether to preserve affordable housing or to maintain folks in those dangerous conditions, or if they can leave out. So HUD Notice 2018-09 is on 208 to 213 of the record, and the HUD Notice regarding enforcement is on HUD Notice 2018, and that's docket 40 within the record. So it's very clear that HUD can pursue both. That's why they got that additional funding.
All right, thank you. We have your argument.
Thank you.
Case under advisement.
Case number 22-1217 et al. Sierra Club petitioner versus United States Department of Energy. Ms. Eberly for the petitioner, Mr. Anderson for the respondent, Mr. Brightfield for the interveners.
Good morning, and may it please the court. My name is Louisa Eberly, representing petitioner Sierra Club. I'd like to reserve 3 minutes for rebuttal. These cases challenge the Department of Energy's orders authorizing exports from 2 liquefied natural gas terminals along the Gulf Coast. We're here because Energy says that Sierra Club isn't entitled to review of the agency's responses to our comments, even though we followed its instruction. Today, I'll talk about 3 things. First, the jurisdictional issues. Second, Energy's arbitrary denials of the rehearing requests. And third, the merits of 2 NEPA claims that are ripe for this court's review. But to set the stage, Energy has chosen an unusual process for evaluating export applications. Energy decided to conduct several general studies with general comment periods. And Energy instructed commenters not to resubmit their comments in project-specific dockets, including the 2 dockets here. So that's what we did. But now Energy has changed its mind. So turning to the threshold jurisdictional issues, standing, the only dispute is whether these orders will actually increase the volumes of exported gas. Energy argues that these orders don't increase the amount that the companies are authorized to export, but what they do is allow the companies to export gas to countries that actually want to buy it. So as a practical matter, these orders will increase the gas that can be exported by at least 12%. Energy assumed that these amendment orders would increase gas exports, and those assumptions are entirely warranted given basic facts about the LNG market and economic principles.
The requirement to establish standing isn't, though, that we assume something is going to happen. It's that you establish a substantial probability of injury. And a lot of the facts in the record that you point to are in your reply brief. And I remind you of Sierra Club versus EPA from 2002 and our Circuit Rule 28A7 that say that you are supposed to avert to any facts in support of standing in your opening brief, not in your reply brief. So, A, why should we entertain or consider at all any facts that you avert to for the first time in your reply brief? And B, if we don't consider any of those facts in your reply brief, what in your opening brief establishes that substantial probability of injury?
As to your first question, the purpose of averring facts in the opening brief is to facilitate the parties to litigate the issues. And here we have fully been able to litigate this.
Well, we don't know what the response is to the facts that you put out in your reply brief because the respondents and interveners don't have a surreply. And it's not guaranteed that we're going to hear argument. I mean, nobody's entitled to argue.
Yes, Your Honor. Our reply brief doesn't just raise new facts. It points out the basic economic principles and common sense that are at issue here. And Energy's own orders and the general studies that are cited refer and assume that the orders here will, as a practical matter, increase exports. So even if this court doesn't reach the issues in the reply brief, there's still sufficient evidence here and common sense and economic principles to support a finding of standing in this case. And those basic economic principles are that more countries available for exports broadens the market and makes it easier for the companies to actually sell the gas. There's nothing in
But we don't know whether they would sell all the gas anyway.
There's strong indications and a substantial probability here that without these non-FTA approvals, they would not be able to sell this gas. It's just a handful of countries, only 7 countries received US LNGs in 2016. And
Facts from your reply brief. Those weren't facts in your opening brief.
correct. But the assumptions that Energy made were that these amendments would increase exports. They relied on the benefits that would come from increased exports throughout the orders here.
Can I ask, were you on notice that there would be a strong argument against standing, given that the agency in the prior proceedings conceded that there would be an increase in exports of US LNG associated with these applications? And I'm just unclear as to what the posture was when you wrote your opening brief and whether your arguments in your reply brief were in response to a more specific argument that maybe you couldn't have anticipated.
Yes, Judge Pan, our opening brief was replying and anticipating what Energy had assumed in its orders, which was that the non-free trade agreement approvals here are critical to actually exporting this entire amount of gas. So we were responding to that, and our reply brief provided some additional information to flesh that out. But yes, based on what we had previously seen, Energy had never previously articulated in the orders that it anticipated these non-free trade agreement orders would simply allow the companies to displace of gas that would otherwise be sold. Turning to party status, Energy waived this claim processing argument by waiting until litigation to raise it. The text of the Natural Gas Act does not frame party status as a jurisdictional bar, and this court has actually granted equitable exceptions to non-parties. And that type of equitable exception is only allowed because this is a claim processing rule. And even if Energy didn't waive this argument, Sierra Club properly intervened here. Energy.
Where is the grant of jurisdiction for our court to review this order?
The grant of
It's
jurisdiction.
in 717 RB, right?
Yes.
On the filing of such petitions, such court shall have jurisdiction. And the such petition refers up to the aggrieved party.
It refers up to a petition that needs to be filed.
Petition filed by the aggrieved party.
It doesn't explicitly tie the party portion to the petition requirement. And under Supreme Court precedent, it has to be a very clear statement by Congress. And so this simply isn't that clear statement that's required. So it's not a jurisdictional bar. And again, even if this is a jurisdictional issue and Energy didn't waive it, we properly intervened. Energy never indicated that the proceedings had terminated, and instead Energy kept these proceedings active by choosing to use them for the amendment in gas increase orders at issue here. Because this court has jurisdiction, I'll turn to why Energy's rehearing orders were arbitrary. This is not a case where Sierra Club waited until the last minute. Energy knew our concerns and actually addressed most of them. But for the first time ever, Energy said that Sierra Club needed to re-protest. In its brief, Energy now admits that a party may object through a motion to intervene instead, and this lets the horse out of the barn. The rules provide multiple avenues.
Where did they say that?
They said that there's a header on page 30 of their brief, and then also pages 35 and 38. And they refer to motions to intervene as an acceptable alternative to protest in their brief. So the rules provide multiple other vehicles for participation.
Oh, the motion to intervene, but the petition for rehearing, that's not they have not conceded that the petition for rehearing can be filed instead of the protest.
Correct. Yes, their argument is that.
So I just want to ask, why didn't you file a protest in this case? Because it seems that you've done this many times before and you've normally filed a protest before then filing a petition for rehearing.
So why we didn't file isn't at issue because we're not claiming that we had good cause for not filing, but ultimately we didn't file a protest because we didn't think that we were required to. And we weren't required to based on the rules.
So have you ever before filed or appeared for the first time at the petition for rehearing stage and not filed a protest?
I am not aware of a time with this exact fact pattern in the past.
But if you thought that that was the procedure, why would you ever file a protest?
So there was one prior example with respect to Jordan Cove, the LNG terminal at Jordan Cove, and there we filed a protest, but the protest raised issues that went beyond the kind of general proceeding type comments that are at issue here and actually went into raising concerns about the scope of the comment period that
Did file a
Energy.
protest. So is your answer that you're not aware of any other time that Sierra Club has come in at the petition for rehearing stage and not first filed a protest?
I am not aware of one because
So
it's not
it just
required.
strikes me that you've framed your argument here as one of arbitrary and capricious action by the agency. And how is it arbitrary and capricious for an agency to deny your petition because you didn't follow their procedural rules if they're applying those procedural rules consistently? How's that arbitrary and capricious?
The issue is that they're not applying this consistently. They have never done this
But you've just
before.
said you've never done this before. Are you aware of any other incident or action where a party came in just at the petition for rehearing stage and never filed a protest first and were allowed to have their claim heard?
There are other examples where we have filed a motion to intervene without filing a
That wasn't
protest.
my question.
And here we did file a motion to.
That wasn't my question. Can you answer my question?
I'm not aware of another example exactly like this.
Then how are they not applying their rule consistently?
Because they gave us instructions that told us that we didn't need to refile our concerns about the general studies. In the notices for the general studies, they explicitly stated that commenters on the general studies need not refile in the project-specific dockets. And those notices listed out several dockets, including the two that are at issue here. And so by filing our comments in those dockets, then Energy posted our comments from those general proceedings into the dockets at issue here. So we
Are you
thought,
aware of any other time in which you are able to preserve a claim in a petition for rehearing by just objecting to the studies and not filing a protest?
I am not aware of that, but the distinguishing issue here is that we had raised these issues before. So the agency was aware of.
All I'm trying to get at, counsel, is that you're saying this was arbitrary and capricious, but if they're applying their rules consistently, I don't see why it's arbitrary and capricious. And you can't identify any other time where they've applied these rules in a way that's different from how they did this time. You're saying this is the first time, I guess, that you're raising this issue. So I just don't see why that's arbitrary and capricious.
It's arbitrary and capricious because every indication given to us was that this was the proper way to proceed. And only after the fact did Energy indicate that this was a different interpretation. And there's no support for Energy's position that these other forms of participation, including the additional procedures that Energy themselves created. They created these other additional procedures in the general dockets. They told commenters that commenters need not submit their comments in these other project-specific dockets. And we followed those instructions. There was nothing else in the rules to indicate that we needed to do this differently. And so the fact that Energy is changing the goalposts after the fact based on things that actually aren't in the rules is what makes this an arbitrary denial of our rehearing request.
We'll give you some time on rebuttal. We'll hear from respondent.
Good morning, Your Honors. Christopher Anderson for the Department of Energy. I'd just like to make a couple of quick points on the jurisdictional arguments before turning to the merits. First, on standing, it was Sierra Club's burden to establish a substantial likelihood that these orders, if vacated, would result in fewer exports and less vessel traffic in the areas frequented by their members. Sierra Club didn't even attempt to do that in its opening brief. And in its reply brief, it merely refers to basic principles of economics. There is no basic principle of economics, however, that dictates.
Can I ask you though, is it true that you didn't make the argument in the proceedings below that there's going to be a displacement, that's all that there is here, so therefore not a net increase in exports?
So we did not address standing below because of an administrative proceeding, but we disagree with Sierra Club's characterization of what the department said. The department hypothesized that these orders would increase shipments so that it could analyze what the effects of those shipments might be on energy markets and on the environment. But hypothesizing that might happen is not sufficient to establish a substantial likelihood that it will happen for standing purposes. If the department didn't do that, there would be little point in the public interest analysis that's required to conduct as part of the Natural Gas Act.
It seems though the way it was, at least one of these examples was phrased was your order acknowledging that there will be an increase in exports of US LNG associated with the applications, but you can't conclude that these exports would increase global GHG emissions in a material or predictable way. That seems to be a concession that there's going to be an increase in exports. You just don't know what the effect of.
Well, so the analysis looks at all exports, both to free trade agreement nations and non-free trade agreement nations. Now, the free trade agreement nations have to be approved by statute, but
this was associated with the applications, which was for an increase in the non-FTA.
I believe both companies applied for both free trade agreement and non-free trade agreement increases in the same application. They were granted in different orders, however. But the fact that Energy didn't distinguish in its analysis of the exports between free trade agreement and non-free trade agreement nations doesn't relieve Sierra Club of its burden to show that if this court grants the relief that it's requested, that relief will actually, or with a substantial likelihood, address the injuries that their members assert.
I guess the thing that I'm trying to figure out is if you took a position previously conceding that exports would go up, and then Sierra Club says in their opening brief, exports are going to go up, and that's going to injure our members. And then you make a more specific argument about displacement of energy, et cetera, in your opposition brief. May Sierra Club then in their reply brief address this displacement argument that you raised for the first time in your opposition brief?
So I don't think so, Your Honor. Under this court's precedent, it's their burden to establish all the facts necessary to establish standing in their opening brief. But even if you consider the facts that they presented in the reply brief, we don't think those are sufficient to establish the substantial likelihood that's required for them to show that their members' injuries are actually redressable by this court.
It seems to me that your argument seems to assume that they can max out their exports to the FTA countries, and therefore adding the non-FTA countries doesn't increase exports. But I don't know that that's supported by the record. Why would they even ask for the non-FTA countries if they're already maxing out using the FTA countries?
So to take your second question first, I think there are a number of reasons why the companies might want the additional export authority. It is true that it creates more customers. There might be better prices in different markets. It might make it easier for them to find their customers. But the fact that it might make it easier for them to sell the full amount of their authorizations doesn't mean that there's a substantial likelihood that they won't be able to find free trade agreement customers for the full volumes. So that is why they might seek it. Energy does not forecast whether the companies will or will not be able to sell the full amount of their authorizations. Energy, for purposes of analysis, assumes that the full amount authorized will be exported. But that isn't a concession that is necessarily true, or that that both authorizations are required for that to pass. It's simply an assumption for analysis purposes and not a forecast of actual market conditions. But standing requires actual facts on the ground, and that's why it was Sierra Club's burden to provide some market analysis, at least, that would make it plausible that these companies wouldn't. And we're only talking about approximately an eighth of their authorizations. Were this a different situation with different percentages, maybe Sierra Club's common sense argument would have some merit. But in this case, when you're talking about really a slice of what's authorized, we think they need to do more.
I mean, whether this is waived or not is another question, but it seems that they said that in order for the FTA markets to absorb this additional capacity, the existing levels would have to go up by 43% or 47%, something like that. And that seems to indicate that they're not currently maxed out, which means that adding this ability to sell to non-FTA countries would likely increase exports.
So I think whether there's a substantial likelihood is a judgment for the court to make, but I would say the orders, all of these orders presuppose that the market for liquefied natural gas will expand. If not, if there were no more demand than what's currently in the market, then no company would seek to enter the market to sell gas. The other thing that I would say about that is even the statistics that they cite, which are just for last year and are not projections of the future, show that there is enough demand from existing demand from free trade agreement countries to absorb the volumes that we're talking about here. And so I don't think that alone is sufficient to establish the substantial likelihood that they need. If I could move on to the intervention point, and the party status. So this court has held that party status is jurisdictional. It held it in 1960. It's reiterated that point on several occasions. But even if that weren't stare decisis, I think that the text of 717R is pretty clear that party status is part of the jurisdictional grant in that statute. 717RB begins any party to a proceeding may obtain review. And I would also refer the court back up to 717RA, which says that no proceeding to review any order of the commission shall be brought by any person. Any person refers up to the top of the paragraph, which is any person which is a party to the proceeding. So we think that it's pretty clear that the statute only contemplates that parties to the proceeding may seek judicial review.
Their argument is that they were a party to the proceeding because this proceeding is essentially the same as the prior proceeding where they were explicitly, affirmatively took steps to become a party.
That is their argument, Their Honor, but it's incorrect under the department's rules. The department's rules clearly distinguish between dockets and proceedings. Dockets are essentially files that contain the administrative record. Proceedings is the process by which energy receives, evaluates, and makes a final order on an application.
How does one know when one proceeding stops and another one begins?
Sure. A proceeding begins with filing an application and it stops with the issuance of a final order subject only to any proper request for a hearing and judicial review. And in this case, the proceedings that Sierra Club says that they intervened in fact, they did intervene in, ended years ago when the department issued final orders. Sierra Club sought rehearing, the department denied rehearing, and then Sierra Club declined to seek judicial review. That brought that process to an end. And having that beginning and end, Your Honor, I think is really important, not just for the department, but also for the parties. Applicants need to know when their applications are approved or denied with finality so that they can plan their affairs. And the department needs to know when it can deem proceedings to be closed so that it can move on to address new applications and new issues.
So are you saying that you require a new motion for intervention for any amendment or uprate or any additional proceeding?
For any new application, if a party has intervened in a proceeding on an application and that proceeding is terminated, which is undisputably the case here, then if there's
It's because you issued an order on that first application.
yes.
So it seems that in Jordan Cove, that's not what happened, right?
So Jordan Cove was a different procedural, the department followed a different procedure that it no longer follows. So Jordan Cove, the department issued a conditional, not a final order. And subsequent to that conditional order, Jordan Cove moved to amend its application. And Sierra Club did actually file a protest in response to that amendment, but there wasn't a final order, so that proceeding hadn't terminated.
Okay. They just didn't have to file another motion to intervene.
Exactly, Your Honor, exactly. But in this case, the proceeding had terminated and it was necessary for Sierra Club to file a new motion to intervene in response to the new application.
So it's your practice in all these cases to require another motion to intervene under
So this has not happened before that we're aware of, that a proceeding has terminated, a new application has been filed, and a party hasn't voluntarily issued or submitted a new motion to intervene or a protest in the application. So this is really a situation of first impression for the department.
So people normally routinely file a second motion to intervene.
I am not aware whether they routinely file motions to intervene or just protests. I can check with the department and provide you more information. I don't want to speak out of turn.
But they can file a protest, but then they're not a party.
That's correct.
I see.
We've never had, I can tell you, Your Honor, that we've never had a circumstance where there was an application, a person did not file a motion to intervene, and then that person also attempted to seek rehearing after the final order. That has never happened before, and that was the issue of first impression that the department decided in these orders. I see my time's up. If the court has no further questions, we would ask that petitions be dismissed or denied.
Thank you. Counsel for interveners.
May it please the court, Jonathan Brightville from Winston and Strawn. I'm here to address the merits, and in particular that a federal agency only has the statutory authority that Congress grants it. Statutory Interpretation 101 as it relates to administrative agencies. And the Department of Energy itself has said that under Section 3A of the Natural Gas Act, it does not have the statutory authority to consider environmental effects that are upstream and beyond and downstream and below marine transportation of natural gas when it is making an export authorization determination for a non-free trade agreement country. DOE has enshrined this statutory interpretation into law by way of a duly promulgated final regulation that was subject to notice and comment rulemaking and created NEPA categorical exception B57. So the principles of the Supreme Court's precedents, including public citizens, and then this court's subsequent decisions applying public citizens to instances where you're dealing with administrative agencies with limits on their statutory authority mean that such an agency also does not have to do NEPA as to such a question. So notably here, I know the $1 million question that you all want to know is like, okay, how do we get to that, right? And I think—
Can I ask you a question, Counselor?
Sure.
Was this argument that you're making raised by one of the parties? Because as an intervener, you can only raise arguments that were raised by the parties. Isn't that right?
So with respect to that case law, someone made the point that we don't get a surreply. And in fact, the case law here in the DC Circuit is different as it relates to respondent interveners as compared to petitioner interveners. In fact, Judge Wilkins, one of your per curiam opinions in Mozilla v. FCC is really the precedent of the type to look at as it relates to the type of argument that we're bringing here. So that was 940 F. 3rd 1, which derives from a long line of precedents from this court that deal with the different circumstances here where we have a respondent intervener who is presenting arguments that were made before the agency. Sierra Club, and I can cite you to those parts of the joint appendix as well, joint appendix 411 to 412, joint appendix 414. So Sierra Club itself, before the agency recognized that the issue of the agency's statutory authority to consider indirect effects, cumulative effects, greenhouse gas emissions around the world, that was a gating issue under the Supreme Court's public citizens precedent and this court's precedents under Freeport and very recently back in May, as it relates to the Department of Energy and FERC and their application of the Natural Gas Act.
These are pretty important issues you're asking us to address in the context of a case where there may be three different reasons why we either shouldn't or can't get to the merits.
We acknowledge, Your Honor, that there are some predicate issues here that the court may very well want to reach first and may very well reach first, standing, obviously, and then the procedural question. But this is a gating question that comes between the merits issues that have been presented by Sierra Club and those procedural questions. Because if this court concludes, as it should already, because what we're really talking about here is the flip side of what this court has already held with respect to the Natural Gas Act in FERC, in Freeport 1, and more recently in the Center for Biological Diversity, the FERC case, which we cited in our 28J case. In those decisions, this court recognized that under the public citizen standard, where you have the Natural Gas Act, and there we were talking about FERC, but because the Department of Energy has exclusive authority regarding the export question, FERC doesn't have to do NEPA on the questions that are beyond their authority and within the exclusive authority of the Department of Energy. This is the mirror image of those holdings and of those cases. It's the same statute. If you go to that statute, right, you can read in Section 3E that FERC, so now we're talking about upstream, from DOE has exclusive authority to approve or deny an application for the expansion or operation of an LNG terminal. So there's no question, there should be really no question under this court's prior decisions that DOE does not have the authority to look upstream. And with respect to downstream and beyond marine transportation effects, we have the insights of the agency itself construing its own statute that at the point at which marine transportation passes into international waters, that is now likewise also beyond their statutory regulatory authority, beyond the scope of what they look at for purposes of a public interest analysis. And therefore, also do not have to do NEPA. That is why they did the categorical exclusion for marine transport, because that is the scope of their authority and their authorization and the scope of the environmental effects that they've argued that they can consider. Although my client wouldn't actually see even at that aspect of it, but it's secondary for purposes of this proceeding.
All right. If you could bring your argument to a conclusion.
Okay. I just want to make sure in terms of, Sonoma's, in terms of the presentation of this, Sonoma Financial Corp, 952 F second 426, Village of Bennisville v. FAA 457 F third 52. It's a different standard when you're dealing with an intervener who presented these arguments below. We unquestionably did. We responded to the Sierra Club having raised these. We sought leave to answer. We did answer. We intervened in this case to make these arguments. And this court's precedents, we feel, are very strong that these preceding issues to getting to their alleged procedural snafus are properly before this court and should cut off any determination on the merits for Sierra Club. And to the contrary, there should be no remand. It should be resolved here. As you said, Judge Wilkins, Rule 1, just, speedy, efficient result of cases. My clients do not want to go back to the agency. They want it resolved here, and it should be resolved here on the merits if you get past the procedural issues.
Not sure Rule 1 applies in the administrative context. All right. Thank you.
Thank you, Your Honor.
All right. We'll give you 3 minutes for rebuttal.
Thank you, Your Honor. Starting on standing, I just want to flag that the orders here were about the non-free trade agreement approvals specifically, and only about the non-FTA portion. They didn't cover the FTA portion. So the citations that we gave to those orders where DOE assumed that exports would increase as a result, those were related to the non-free trade agreement approvals here. And in the Airlines for America case that we cite in our brief, in our reply brief, that case found that there is no additional evidence required if basic economic principles support the presumption. And here, the situation was that TSA had increased fees, and that would therefore increase airline prices and reduce demand, harming airlines. The airlines had standing in that case. And there's no evidence to support the speculation here that there is enough demand in free trade agreement countries. Judge Pan, as you noted, sending all of this gas only to free trade agreement countries would require a 47% increase in the amount that those countries received as of 2022. And then turning to the party status issue, the cases cited by the department refer to person aggrieved, not talking about the party status requirement. And Energy just acknowledged that claimed that they changed their policy since Jordan Cove, but they haven't actually announced a new rule here. This isn't a place where they announced a new rule in the rehearing orders. They didn't challenge our party status in the rehearing orders at all. And if they had, we would have had an opportunity to address that potentially through late filed motion to intervene. And the notices here were referring to amendment applications. So that gave us the indication that they meant for the proceedings to continue. And then turning to the discussion about whether a protest was required, the department concedes that protests are not required and that they're not the only vehicle for providing objections to the department. You can do that through a motion to intervene, which we did. You can do that through the additional procedures, which we did here. This is a special situation because Energy has used these additional procedures opened in the general studies in order to accept party objections. We've complied with those instructions, and for those reasons, Energy's denial of our rehearing request was arbitrary. We ask this court to vacate the orders, rule now on the 2 legal issues that we will rest on the briefs for, and remand to Energy. Thank you.
All right, thank you. The case is submitted.
Honorable